Hello, and welcome to People's Through the HR Lens, a comprehensive market update that looks at the leading HR trends impacting the Australian workforce. Hi, I am Leanne Lazarus, Recruitment Manager here in the People to People Brisbane office. On today's edition, we will be focusing on what penalties can employers face if they breach the right to disconnect laws in Australia. This week again, we are joined by Jonathan Mamril, Director and Head of Employment Law at South Geldard Lawyers, to unpack Australia's right to disconnect legislation, what it means for HR leaders and employers, and what is at stake if you get it wrong. The right to disconnect is a new addition to Australian workplace law under the Fair Work Legislation Amendment, Closing the Loop, Act 2023. Effective the 26th of August in 2024, for most employers, it gives workers the right to refuse to monitor, read, or respond to contact from their employer outside of work hours, unless the refusal is deemed unreasonable. What is considered unreasonable depends on factors such as reason for contact, how it is made, and its level of disruption, and the employee's role and personal circumstances. The law doesn't prevent employers from making contact, but it empowers employees to set boundaries when appropriate. To comply, HR teams should prioritize clear policies, staff training, and a workplace culture that respects work-life balance and employee well-being. We are now seeing early cases emerge under the right to disconnect laws. A former Queensland teacher is suing her ex-employer, claiming she was unlawfully dismissed after refusing to respond to misconduct allegations sent during school holidays. She cited her right to disconnect, arguing the contact fell outside of work hours. This is believed to be the first public legal case in Australia referencing the new legislation in a dismissal claim. So what would HR know and prepare for? Well, today we have Jonathan Mamril, Director of South Geldard Lawyers, joining us to run through a few critical points when it comes to the right to disconnect. Welcome, Jonathan.
Hi, Leanne. Always glad to be here.
Fantastic. Well, look, let's jump straight into the questions. So the first question that I'm going to say to you is, what does the right to disconnect legislation require from employers in Australia?
It's a lot of misunderstanding about what the right to disconnect actually is, but the legislation basically says employees will have the unequivocal right to not monitor, read, or respond to any work-related communication from their employer after hours. And this includes contact attempts from, say, third parties related to work, like, say, clients or customers. So for those who are not small businesses, that's already in place. For small business employers, that comes in on the 26th of August this year.
Fantastic. And if we talk about the right to disconnect, organizations that are potentially not compliant, what sort of penalties or impact could they have?
Yeah, it's a pretty hefty penalty regime, because for those HR leaders and HR professionals out there who listen to that line, unequivocal right would give rise to a workplace right. And if you think of workplace right, automatically your head should go to general protections. And so the maximum penalty for employers who breach an order is $18,784, and for an individual, it's $93,900 for per contravention. So you're talking about each contravention having a maximum potential penalty. But also keep in mind, even though there's a penalty regime here, the right to disconnect legislation actually still has exceptions as well.
Okay. So when you say exceptions, what could that look like?
Yeah, great question, Leanne, because this is really the crux of the right to disconnect legislation. Yes, there's that unequivocal workplace right. Yes, we should keep that absolutely front of mind. But also the refusal to connect must be reasonable. Okay, so firstly, is there urgency in the contact? What's the disruption that it will cause? Is the employee getting compensated for the availability outside of regular hours? What's the actual nature of the employee's role? Is the contact infrequent or not usual? But also take into account things like personal circumstances, such as care and family responsibility. So it is a piece of legislation that is a little bit complex, also gives rise to quite a number of issues, such as this pure issue of a workplace right.
Okay. So most people would automatically assume that the responsibility sits with HR, and that way any sort of non-compliance or any sort of penalties would sit with HR.
Yep.
But who within a company is responsible for managing and monitoring compliance?
Well, actually, if you think about the right to disconnect legislation, really the responsibility lies with the employee, right? In terms of, because there's a right to not to connect. Okay, that's the right. So it's just that it's not like there's a penalty for someone who sends an email out of normal working hours. It's not about that. It just means the employee carries the right to not respond. In saying this, from a risk mitigation perspective, if we're looking at it from that perspective, then it's really going to come down to people managers and, of course, HR teams as well.
Okay, perfect. Now, when we talk about contact out of hours, what defines out of hours, and what would be the impact by an employee's role, responsibility, and department?
So I think pretty much every barbecue, any sort of social function I've gone to, any networking function I've gone to, this question's been asked of me, Leanne. Probably not those words, but pretty much the same thing, which is, what's the definition of out of hours? And my answer pretty much all the time is, it depends, right? So it will come down to a number of things. It'll come down to the company, what's the normal office hours, the nature of the role. So what's the expectations of the role? For example, what it says in the role description, what it says in the contract, and also what's reasonable in the industry. So as an example, if the employee is a receptionist and they work in an office that is open from 9 to 5, then you would say the normal working hours would be from 9 to 5. If you were to say, as an example, a project manager, essentially they just got to do the work to get that project over the line or get that project done, then potentially their hours are going to be completely different. And then, of course, you've got all types of other issues such as work from home, flexible working arrangements, remote work, that again comes into play as well. So the answer is, it does depend, but it will come down to a number of different factors.
Okay. So just before I go on to sort of the next question, if we are talking about those working hours, some contracts we find in the market where it will say the business operation hours are between X and Y,
Yes.
and an employee needs to work a 38-hour work week between those hours.
Yep.
Would that impact that out of hours sort of thought?
Yes, the answer is yes. So that would be I suppose, what you call your normal working hours. But there's also, of course, contracts will say, especially salaried employees, they'll say, you'd be expected to work reasonable additional hours. So that would obviously be different. But if you've got pretty strict hours, working outside of those hours, connecting outside of those hours, because the right is the employee doesn't have to connect. That's the right. They can if they want, but the right is they don't have to connect.
Perfect. So earlier on in my intro, I spoke about the first case that's sort of come to light. What is your take or thoughts on that case?
Yeah, so this is really interesting because we haven't really seen any public cases specifically that talks about right to disconnect. Myself and quite a number of employment lawyers always thought that this piece of legislation probably used for other types of claims, primarily workers' compensation type claims, or say workplace health and safety or psychosocial risks types of claims. That's where we thought, and it pretty much is playing out that way. However, this is a bit different because this recent case includes a teacher who was who was alleged to have engaged in misconduct. The school then required them to respond to the allegations, but during school holidays. Now, the teacher just argued, hey, look, school holidays is outside of my normal work hours, but also said, because of that, I can't respond. Okay. Now, the employee was terminated because they didn't respond to that claim. but they filed an unfair dismissal claim, not a general protections claim, an unfair dismissal claim. So the right to disconnect, or what they're arguing, the right to disconnect, is only one of the arguments that they're putting forward. There's other issues where they're saying that they've raised other concerns, especially around complaints that they've made as well, about other behaviour. So it's not the only thing that's being considered. It's just that it is definitely one of the arguments they're putting forward. And keep in mind, this is in the context of an unfair dismissal claim, not a general protections claim. So it's only one part of a whole pile of other arguments that this teacher has. So as much as we're trying to maybe hold on to this as maybe some type of, precedent or something that's going to change things, it may not do so as a standalone application. But considering what it is, it's probably what we're going to see a lot more of, which is essentially that it's going to be basically a side part to what is really the crux of the claim. And I think that's what right to disconnect is going to be going forward.
So it's going to be compounded into a bigger claim, just part of it.
Yes, that's correct. I suspect and I think a lot of other employment lawyers like myself have the same thought about this, that right to disconnect will be used more as an extra part of a claim, or rolled up into, as you say, a bigger claim.
Okay. So the other question I wanted to ask you, just in terms of that out of hours and that contact, how would it work if there is a difference in time zones, or potentially international teams that are employed by an Australian company?
So this is where the right to disconnect really didn't think about the current workplace we're currently in. Current workplaces have huge remote work teams. It's a much more global industry with globalization. We have a lot more global companies involved in Australia with Australian businesses. We have mergers, acquisitions, and so we have all of this in this melting pot of a completely different workplace. And one of those issues, of course, is dealing with, say, things like different time zones and managing international teams. And so, and also, of course, you've got flexible working arrangements embedded in all that. And so, yes, the right to disconnect really probably didn't really contemplate this. So what I say to clients is, okay, let's go back to the brass tacks. What is the actual role? What's the expectations of that role? So let's say you're managing a global team. What are those expectations of that role? When will we have to, if you have to get up at a certain time to attend a board meeting or attend, start of day meetings, when are those going to happen? How's that going to be dealt with? And so partially what you'll have to look at is it reasonable? So does it take one of those boxes? So for example, it is part of the role, the paid to do so, to work in those time differences, then it's going to be reasonable to say, hey, you got to connect during that time. But also you got to consider, well, there is going to be an impact. So it may not be right to disconnect, but it could be psychosocial. It could be workers' compensation. So you got to think about, okay, well, this is going to have some sort of impact. So what I say to clients is, think about swings and roundabouts. There's going to have some flexibility going on. So if someone's going to be working at 12 o'clock at night for 2 hours, then maybe there's going to be a later start, or there's going to be some time off in lieu. Okay, and some awards may have that in place as well, but I'm thinking as well of those who are award free as well. So you got to really, it's not just considering right to disconnect as a standalone thing, because there are pretty much exceptions that talk about reasonableness. So it's not about that. It's about all the other areas, all the other issues, mental health, all those types of areas where you need to be also treading very carefully, especially in the context of remote work, flexible working arrangements, and difference in time zones and international teams.
Absolutely. Now, obviously, the legislation has come in for most employers, and as you say, as of August this year, it comes in for the smaller organizations as well. When it comes to communicating within an organization around the right to disconnect, how should or could HR handle this and educate both the employees and managers in the best way and how to go and how to deal with it?
This is an interesting question that a number of HR teams are trying to handle. So you have your baseline, reviewing your policies, developing policies, not just around right to disconnect, but also around things like flexible working arrangements and remote work. So having absolute clarity on what that means, but also having absolute clarity absolute clarity on expectations, and in particular, communication expectations. So where we see, and I'm talking about our team, the employment law team here at South Geldard, where we see the problems actually is in very high performing or high performance individuals who've stepped into leadership positions, who are expecting their direct reports to essentially work at the same rate. Working late at night, working big hours. That's where we're actually seeing a lot of the problems. So getting very clear, what are the expectations for that role? So, and I suspect, Leanne, there's a lot of roles where actually you probably do need to do that. Yeah, do need to do those long hours, or it's in short bursts. But also talking to that manager and saying, hey, yes, we know that you wake up at 3 o'clock in the morning and you get 3 hours worth of work done before you take the kids to school or whatever it is that you do. However, for those 3 hours, your people aren't awake. Okay, so maybe use technology to ensure that you delay the emails that are getting sent out. Don't make any phone calls to those employees, that your staff, during that period of time. Making those adjustments and using things like technology to make those adjustments. But you'll also need some training. You'll also need some training around that, and in particular, guidance and leadership from people in leadership positions to actually guide and mentor people who are managing those expectations and actually manage that. So, guiding that through, I think that's going to have some clarity. But from a baseline as well, your policies, your contracts, your position descriptions, you've got to review all that as well.
Absolutely. Just in regards to, as you were saying, around expectations and potentially delaying communication or emails if you're up at 3 o'clock in the morning to start doing some work. Some clients have sort of come back to me and said to me, oh, look, I don't necessarily delay the email, but what I do is there's a caption at the bottom of my email to say, look, there is no expectation for you to read and respond to this outside of working hours. Would that sort of cover someone from that perspective, or would you say rather delay the email so that it comes through closer to the working hours?
Either or will work, because it's still about clarity about communication and expectations. So as long as people have clarity around it, most of the time, you'd say about 90% of the time, people aren't going to have a problem with it. It's when you don't have that, when you don't communicate those expectations, that's when there's difficulties. And I'm talking, I'm talking mostly about the employee-employer situation, and mostly in regards to, the communications between, say, a manager and another, an employee that they're managing. But of course, it works very much so with clients as well. And I think if you really look at it, we definitely do still have situations where there are clients that are very demanding, and maybe there are fees that go with that, and that's their expectation. Okay, but also there is a requirement or a need really to go back to those clients and say, hey, look, the expectations are that during this period of time, if you could just delay your emails, or if you want to insert something saying, hey, you don't need to come back to me straight away. But of course, there are going to be exceptions, Leanne. There will be that urgent issue. There will be that thing that someone needs to jump onto. And I say this to every single client, every single one of them. I say, look, if there's a situation where it's going to be urgent, maybe have some sort of layer. So it could be something along the lines of an email can wait, text message within a day, phone call, please answer the phone or call me back. This is urgent. Something simple like that is going to make a huge difference in terms of dealing with these right to disconnect laws.
Okay, perfect. Now, you did touch on, obviously, we need to make sure that our contracts, our policies and procedures are correct. Is there anything that HR should include or have really defined for clarity in both of those?
Yeah, this is a really good opportunity to really go back to your position descriptions in particular. What are the expectations of that role? Especially if you have situations where they're working outside of normal working hours, they're working on a lot of project work, and also if they're working with international teams, international clients, anything like that. Okay, so what are the actual expectations of that role? So make that very, very clear. The other thing as well is the training should then lead to maybe some type of policy that you could utilize, and that could be not just a right to disconnect policy. It could be woven into, say, flexibility, a flexibility policy, or flexible working arrangements policy, or something like that. Okay, so it doesn't have to be that set on right to disconnect, because the law might change, so you don't necessarily be stuck and wedded to it. And just be careful with your contracts. Don't just insert some sort of right to disconnect clause into your contract, because then you need both parties to amend that. So keep it in policy form if that's what you want to do. So it's just about reviewing those documents in the context of what we just spoke about. That there is an unequivocal right, but there are obviously exceptions, and it's really down to the employee to disconnect. But keep in mind as well, and this is the other one that people probably have forgotten, the right to disconnect can work the other way too. You can go, and the employer can say, hey, you've exercised a right to disconnect, but there's actually no right there, because your job, a big part of your job, is to answer phone calls, of clients outside of hours. We pay you to do so, whether it's an on-call allowance or a larger salary or whatever it is. So it can actually work the other way. Now, are we going to see that? Maybe, but definitely can work the other way. So let's not keep harping on about it's on the employee. Actually, a lot of the responsibility on the employee, actually, the right to disconnect. But also an employer can say, hey, it's actually not you're trying to exercise a right that actually doesn't exist.
Okay. So that's definitely food for thought. So if you were able to talk to HR teams or even broader leadership teams today and give them a bit of a focus or a cheat sheet in terms of what they need to do around the legislation and the impact it will have on their business, what would the short version be for them?
Short version. Okay. All right. So firstly, the right to disconnect is it's a misunderstood piece of legislation. Okay. It does come down to really the employee doesn't have to connect. Okay. They don't have to connect outside of whatever your normal working hours are. They don't have to. However, there are exceptions, right? Most of the exceptions are what you probably think of. Urgency, it's part of the job. We pay to do so. So there are exceptions. That's fine. But keep in mind, where this problem is going to occur most of the time is going to be with managers who are high-performing managers and expect their staff to do exactly the same, or organizations that don't have clarity, organizations don't have clarity around expectations and communication. That's where you're going to see the problems. And there are penalties that are related to all that, and there are ways to put some risk mitigation in place. Technology, policies, contracts, training. Is that sure enough?
Yep, I think that's always tough to put it in summary, anything that's legal related. So thank you very much for that. And Jonathan, thank you so much for joining us today, for your time and for sharing your insights and information into such a relevant topic of the right to disconnect and the focus HR needs to have. If any of our viewers have any questions around the right to disconnect from a legal component, please reach out to Jonathan Mamril, Head of Employment Law and Director at South Geldard Lawyers. But thank you very much for joining us today, Jonathan.
Speak soon.
And thank you to everyone that has joined us for the session today. I hope that you have found it very insightful and informative, and we look forward to you joining us for our August session. Our 2025 Employment and Salary Trends Report has been released. This comprehensive looks at the latest workplace hiring and job seeker trends across Australia and can help you and your business make informed decisions. If you'd like a deeper dive into salaries, benefits, and workplace trends across your market, you can request your copy by scanning the QR code on the screen or click the link in the comments below. And lastly, if you're looking to grow your HR career or build your HR team, I'm here to help. Whether you're searching for your next opportunity or just need the right talent for your business, our teams across Australia, New Zealand, and the UK have you covered. With over 10 offices, we can connect with you and the right opportunities to set you up for success in 2025 and beyond. Contact me, Leanne Lazarus, today on leanne@peopletopeople.com.au or 0431 819 724. Thank you for watching, and we look forward to seeing you next time.